Yeah, so you mean to tell me that nobody from them, not the lawyer, they ain't have a problem filing that fraudulent complaint, but nobody
Yep,
showed up for them?
yep. Because I
Wow.
even asked him when we walked out. I asked him. I said, "So do you work for Velocity?" And he said, "No, I don't." He said, "They didn't have anybody to come out." But anyway, he said, "Yeah, if they don't have somebody to come out, they put their feelers out and get somebody locally." I said, "Oh, okay, so you're local to Findlay?" And he said, "No, I'm actually in the Columbus area, but they didn't have anybody in this area at the time that we needed to be here, so I picked up the job." And
Wow.
you picked up the
Picked up a
job?
job? What is some
Like,
fuck? What you delivering packages?
Don't forget to like, share, and subscribe to the New Culture Empire.
So, a $17,000 complaint for judgment was filed against my client in the amount of $17,314.84. Now, that is no pity patch little change. It's a big significant money to have to pay a creditor. But they filed the complaint. They had a copy of the original debt in the agreement, and we were ordered to respond. We responded with a motion to dismiss. The judge overrules that motion to dismiss and orders a response. I doubled down on the same arguments in the motion to dismiss in the response that we were ordered to give to the courts. The judge schedules a pretrial. Now, at this stage, this is where 99.99% of pro se litigants lose, because this is where the creditor gets the judgment or they get summary judgment in their favor. So the mere fact that I doubled down on the same arguments that was in the motion to dismiss that was overruled, and the judge scheduled a pretrial, a civil pretrial, that opens the stage for us to now move for summary judgment, because they didn't get their judgment at the beginning, which they seek. So when a case goes to pretrial, the creditor's case starts to crumble. The hardest hurdle in court is getting to the pretrial stage. It's very hard. It's not easy as they try to make it seem. But they are stuck at their original filing, in which we invalidated, even though they had a copy of the debt, even though they had everything that shows that they're the current creditor or the owner of the account, and they still didn't get the judgment. This is very important. Now, stay tuned to the aftermath of the pretrial. Yeah, so you mean to tell me that nobody from them, not the lawyer, they ain't have a problem filing that fraudulent ass complaint, but nobody
yep,
showed up for them?
yep. Because I
Wow.
even asked him when we walked out. I asked him. I said, "So do you work for Velocity?" And he said, "No, I don't." He said, "They didn't have anybody to come out. So
Wow.
usually what happens in a case, I know." He goes, "Usually what happens," and I was just like, "Oh, okay," like just nonchalant, like, "Oh, that makes sense." But anyway, he said, "Yeah, if they don't have somebody to come out, they put their feelers out and get somebody locally." I said, "Oh, okay, so you're local to Findlay?" And he said, "No, I'm actually in the Columbus area, but they didn't have anybody in this area at the time that we needed to be here, so I picked up the job." And
Wow.
you picked up the
Picked up a
job?
job? What is some
Like,
fuck? What you delivering packages? What is this,
I know.
outsourcing?
I couldn't believe it. I was like, "You've got to be kidding me. This is how these bottom feeder lawyers deal
What
with stuff?"
the hell? I've never heard that in my life, where a law firm or lawyer, whoever is representing them, is not in
Hire.
court, and you just go hire someone right off the bench.
Yeah.
Oh
That's
my
why I
God.
asked him specifically. I was like, "Oh, so because he said he was standing in for whatever her name is,
Right.
Noreen or something." And so when we walked out, that's why I asked him. I said, so Noreen couldn't come today, so you're part of Velocity?" "No, no, no, I don't work for Velocity. They had nobody to come out, so they just put feelers out and to have somebody come in so that they don't show up." But in my
Wow.
opinion, they didn't show up. I mean, is it different than if I hired somebody to come, like, or just have like a friend who knows what to say in court? I'm
Right.
going to have her come and
Right.
speak on my behalf.
Because if that's the case, I should be able to just come and come show up for you now.
Yeah. Yeah.
So you're not affiliated with them. You don't work for them. You were just hired just to show up.
Yep.
The lady purposely did not show up.
And he did say something. He didn't say how much. He said, when he said they just put their feelers out and they hire somebody else, and he said, and I don't know why, companies would do that because then they're just spending more money. So he obviously is getting paid for it.
Wow.
I was like, oh, okay. And that's why I was just like, oh, yeah, that makes more sense. And meanwhile, I was like, okay, go away because I need to write all this down with my pen.
Right.
Because I didn't
So
want him to think I was taking notes.
right. So but remember, because today, well, what they were supposed to do was contact you according to the order. But you notice in the order it said substantial procedural issues. So
Yep,
she could file the lawsuit, go down to the courthouse and file it, but she couldn't show up in court today. Huh.
yep,
I find that very weird. So what did the judge
yep.
say?
So basically, what the guy, when he showed up, it was like five of. And I mean, I had been there when you messaged me, like I had already gotten there, signed in, like I was there 45 minutes early because I wanted to go over all the paperwork
Right.
again, like so it was
Right.
fresh in my mind.
Yes.
And so the part where he said he only had like the last 3 pages, which are the last 3 things I sent you, and it said
Right.
like discover deadlines, exchange of witness list, blah blah
Yep.
blah. So he said before we go in there, because a lot they like us to discuss things beforehand, and I'm thinking, okay, well they didn't. That's when I thought he was part of Velocity. I was like, oh, okay,
Right.
maybe somebody should have called me beforehand because then
Most
some of the things,
most definitely they should have called you beforehand.
yeah,
This is blindsided. You don't
yeah,
know him.
nobody did, and so
Wow.
he said, well, he's like, can we just go over this real quick before we go in there because the judges like it to be, in order. I said, sure. So he had to elaborate because some of the things I wasn't exactly sure of, and I didn't want to agree to something without knowing.
Right.
So he's like, exchange of witness lists, and I said, what witnesses? And he said, well, do you have any witnesses? It's probably just you. And I'm like, well, yeah, it's just me. So he just went down the list, and the one thing, I think it was issues in
Yeah. Yeah.
issues including okay, I think it was that one. And I said, he asked if I needed any more information, and I said, well, I don't know if you had a chance to read everything that I have filed, but
Right.
I showed him because I have copies of all of it, and I just showed him the fact, and I said, they have not proven that. Yeah,
Right.
I read it because I was like, hold on a second, and I went back and I looked where you had written, and I'm like, okay, and then I said to him the basically the
Right.
contract thing
Right. Right.
that they
Because
have not shown.
that
And he said, okay. He says, well, and then he wrote that down, and he said, anything else? And I said, well, I mean, they should have given you this to read. And meanwhile, I'm thinking like he works for them, so like why didn't he read it? But
right.
he
It's
doesn't.
what the
They
fuck?
literally.
What is going on?
I'm telling you, this state is backwoods. I'm telling you.
What the hell is he don't
And
even know?
the judge was like super nice. Like we literally sat in this little room
Oh
with a little
God.
table for like 6 people, and he sat. And I'm thinking, I watched. I think it was in Kentucky where something happened with the judge where the guy,
Wow.
because
Wow.
there's like, yeah, they do have a courtroom, but I guess we were, because I asked him, because he said, well, is there anything else that you want to accomplish today? And I said, I want it to be over.
Right.
I have all these reasons why they have no reason. I said, I've never taken a loan out with Velocity. I have a lending club. So I said, in all honesty, I don't understand why this needs to continue. I expect it to be over today. And he said, well, this is just the pre-trial.
Cool.
Oh, for fuck's sake, are you kidding me?
Yeah, no,
So anyway, I
but
said,
here's the
okay.
thing. But here's the thing though. The judge actually did us a favor by
Mm-hmm.
scheduling this hearing today because most people, the judge just would have entered a judgment in favor of Velocity at that stage. So since he
Yep.
didn't give them, the judge did not give them the judgment right then and there. You got to remember a thing, Karen, and don't let them try to hoodwink you on this. There
Mm-hmm.
had all the elements that you told them, yo, y'all all the elements we put into motion, they were supposed to have all the evidence that we said they didn't have. So they can't come back and try to resupplement or try to amend their complaint and attach it because it will be prejudicing you because they can't
Yep.
retroactively go back. So that's why
Okay.
this is why
That
the
makes
judge,
sense.
right? This is why the judge didn't issue the favor. It's at this
Okay.
stage right now that we can now move for a summary judgment. It's at this
Okay.
stage. So this is a
Okay.
motion I'm going to be putting together for you, so you can file with the court next week. It's a summary judgment, and
Okay.
we don't even have to let the other party know. They don't even need a copy because it's a summary
Okay.
judgment with the proposed order. Yeah. So we know it's a goddamn pretrial, judge. I mean, you probably didn't know, but this is exactly what it is. It's a pretrial conference. So he said, "Well,
Yeah.
this is just pretrial." So did they set another date?
Yep. Because
Perfect.
he had his book right there with him, and he's looking it up, and he said, so, and he literally, like, most of what, for me, he didn't really look at me to anything other than the date. Like, he was looking at the other guy,
Right.
saying, well, what is, is everything? And I said, well, no, we discussed that outside, and he looked at the plaintiff, and he says, okay, so what is it that you need to come up with that she needs? And he's like, oh, well, blah, 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 basically the
Right.
contract they're not going to be able to come up with.
Nope.
And he said, and the judge says, okay, so is there a certain amount of time that you need? And he said, well, I figured 60 days, but if you want it to be a longer. And so the judge said, okay. And he looks up at his thing and he's going through, and he said, for all depositions from the plaintiff. And he said, okay. And of course he showed up there without a pen, and he's
Wow.
going, so
He
can
didn't
I
have a
borrow your pen?
pen.
I said, absolutely. And I gave him my pen. Well, I had mine in my pocket, and I was like, shit, where's my pen? So I walked into, like, the county clerk, which was right next door where I'd filed stuff. I walked in there, and they were all on the phone. I was like, I'm just going to borrow one of these. And I took their pen, and I gave it back. But yeah, he was like, can I borrow your pen? Oh, absolutely. And I gave it.
Wow.
I was
Okay.
like, God, are you
Oh,
shitting me?
why he didn't even have a damn pen. Oh God. Okay.
So
Yeah.
20 for all depositions from the plaintiff have to be in to the court by then. And he set the date at 1:15 for the pretrial. Another pretrial?
Another a pretrial with a pretrial. Okay. So basically, this is what's going on. Okay. So the
Because
judge.
they don't have all their paperwork? Is that
No,
why there's judges?
no. This is what the judges. This is see. The judge is not what he wasn't going to tell you right in then and there to do. But if he was speaking off the record to you, he would have said, "All right, Karen, this is a time where you need to put your motion for summary judgment in to have the case dismissed because obviously
Okay.
they can't come back and try to file new things on the record now because they're stuck. So this is
Okay.
pretty much your case to drive right now. They don't really have anything, and you cited overwhelming authority, which they can't get the judgment because if you didn't have any merits to your arguments, I just would have ruled in their favor then. You see what I'm saying?
Yeah.
So the judge
Yeah.
knows that they don't have nothing else.
Oh, I
He
figured the judge did, but I thought, well, wait, why are we going to pretrial?
right,
I'm
but
kind of thinking,
because he
they may
can't.
give them and I'll give them the chance.
I know, but here's the thing. He knows that they can't bring anything new into the record because we're going to strike it down.
Oh, got it.
Right? See, he knows
Got
this
it.
already, but he just can't tell you. The judge can't tell you what to
Okay.
do. This is why, if you go back and look at the order again, it goes special filings. Look in that section. It says anything besides summary judgment, you must
Yep.
send the postage to the. This is where, hey, our motion for summary judgment is heard at this stage. So my motion to dismiss, remember the very first filing I did? Guess what?
Yep.
Now is the right time.
Okay.
See, I found the motion
Now
to
it makes sense.
right. See, I found the motion to dismiss first. I know it was premature. I found it first, right? Because I was actually setting a trap for the judge too. So when the judge overruled it, he didn't dismiss it. He overruled it. So when I filed your actual response, most people thought I was going to change it up. Like, well, that didn't work the first time. Actually, I doubled down on the same argument. You see what I'm saying? So the
Yeah.
judge scheduled a pretrial. didn't give them the judgment. So now they're
Okay,
stuck
now
at the
I know why you. I was like, I thought they'd throw it out, and you're like, no, 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 it
no,
doesn't work like that. I'm like,
right. Remember I said
okay.
you went in stages. You win court cases in stages. So since they didn't get the judgment originally, now that was a win for us at that stage.
You're rocking with the best.
Karen, you be honest
Okay.
with you, 99% of consumers never get past the first stage. And look at where
Really?
you're at. Oh, they never ever get past the first stage. The complaint,
Well, and then I
they,
was reading something
yeah,
online, and it that most people don't even go to the, like when they're being sued, they just don't go to court. I'm like, why the frig would you
right,
not
right.
support yourself?
Some
Like, I
people,
mean, if I'm
they,
gonna go down, I'm going down fighting.
right, right. Yeah, no, you're absolutely right. Most people don't show up, or when they respond, they don't know law enough to respond in a
Yeah.
way that the judge doesn't issue that judgment. Normally, I'm telling you, Karen, I've been doing this for a long time. 99% of pro se consumers, that judgment for 17 grand or 20 grand, whatever it was, the judge would have ruled it after your response. So since they didn't get that
Okay.
there, that's a win for us. We now stand in the
You're
1%
rocking
of the
with
other
the
side.
best.
Now, is everything what they supposed to have? They are stuck at their, so if they didn't have it at their, there's nothing they can do at. So what we're doing next week is we're sending a motion for summary judgment to the court.
It's the original creditor. There's no sort of defense regarding assignment on this case. The balance
at the time of the complaint was $4,378.29. Under NCR 2.116, parent I, parent 1.
the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Because we're just going to email them a copy of the motion for summary judgment, and I'm gonna put a letter together for you saying, "Hey, man, how about you just agree with this? How about you just agree with it? Don't object to it. There's nothing you can do if you try to amend your original complaint and try to add some new information that you didn't have at the beginning. We're going to strike it down because it will prejudice us." And your state court of appeals in Ohio State Supreme Court says that these defects that we pointed out, meaning they can't do this in layman's terms. Hey, Karen, you bring up this argument. Hey, they didn't do this, they didn't do this. And they say, oh shit, she's right. Let's go back and change it and then file it. They can't do that.
Well, and when the guy, his name,
Oh wow.
no,
Right. See, that's another thing right there. There should have been someone in there, like a court reporter,
yep,
taking
nope,
everything down that's being said. What the hell
nope.
is going on in Hancock, Cook County? The hell is
I
this?
don't
I've
know. I
never
don't know.
seen a person show up on behalf of a law firm like they just pulled them right off the streets. Like you got a contract with FedEx. You just delivering
Yeah,
packages in your own car. Like, oh yeah, they just hired me just to just to stand in. I don't even know what's going on.
yep. He didn't.
What
He
the
didn't. He
hell?
literally had a manila. He had a manila envelope, not an envelope, a folder with 3 pieces of paper in it. And when
Wow.
he turned the first page, the second page, and I'm looking at, and I kind of looked because he was writing like on his knee, upside down,
Oh
and
God,
asked, like, "Can I borrow your pen?" I'm thinking, there's booths, like there's benches here. Just have a seat, but whatever.
bruh.
So
Like,
then I was looking at what he was writing on, and it was the second page of the last thing that we got that said when the pretrial was. And it was the one where discovery deadlines and blah, 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 all that stuff. So he just went through all those things and made notes. And he said, okay, do we, how many witnesses? No. And he's like, okay, no. So he figured if the judge goes through all of that, and the judge didn't even ask, other than, is there anything that we need to go forward today?
right. Okay, so Karen, I was going to send a summary judgment right then and there to you before this date, but I knew that it wasn't going to be heard in time because y'all actually needed to talk. So that's why I kept texting you.
Oh,
Was like,
okay.
yo, did they talk to you yet? Did they talk to you yet?
Nope.
So I wasn't going right. So that's why I was like, I knew like, all right, they're probably going to talk at court. Or if they
Mhm.
didn't show up at court, I was going to, tell you that if you'd have texted me like, yo, they're still not here, I'd be like, yo, ask the judge to dismiss it. But anyways, but I knew that y'all actually had to speak first before I could move for summary judgment. Because if y'all
Mhm.
didn't talk and if he didn't show up, the judge was just going to continuing the case till you actually talked. It was going to stand still.
Oh, okay. Well,
Right,
that's what he said too. He said, let's just go over this. And he got there literally five of, because I'm looking at the clock, and he said, let's just go over this real quick. Did anybody discuss this with you? And I said no. And he said, okay, well, just because the judge likes us to go over
right,
stuff so that when we walk in there,
right.
we both agree on certain things. And I was like, okay, that's
Right,
understandable.
right, right. But
Yeah.
the main thing now is next week you'll be having your motion for summary judgment. This is our stage to win now. This is our
You're
stage right
rocking
here.
with
This
the
is our opportunity
best.
right here. Because I don't give a shit if they put the original Dead Sea Scrolls on the record. I'm going to strike it down. No,
Mhm.
you cannot come back and try to change. They cannot come back and change the record, change what they filing. If they didn't show up, Karen, whoever that not Karen, whoever that lady was that filed the lawsuit, she didn't show up.
Doreen.
Corrine, yeah, she had all that to say. She can attach a
Yeah.
100 pieces of paper, but you can't. Now she obviously. So if they ain't got nobody in the office in your area, then how did they get all the way down there to file the lawsuit?
Somebody had to cut. They must have sent somebody down to do it.
That
But
don't.
wouldn't it say that person's name on there?
Yes,
So like if
yes,
he didn't come by herself to file, then she would have had to write something on there stating that on behalf
yes,
of me.
yes. But
I
yes,
mean,
the lawyer went there and filed the original suit, though. You get what I'm saying?
okay. Yep,
But they
that's what I thought.
But
But
they
I went over.
did. Nah, they did, but they didn't show up today.
Yep.
Mm-hmm. Don't worry. We got them. We got them. You all
Well,
you
and the
do.
funny thing was, I was like, wait, so you're like a stand-in lawyer? Like, what? Do you do this for a living? Like, you just go around and pick up jobs because,
Right. What
like,
the hell? What a
do they have a
loser.
website? Do they have a website that states,
Right.
okay, so we can't be in court. Is there any job? We'll give you $100.
Right. What a fucking loser if that's his job. Yo, no way. Hell no. So, but did you clear is he really an attorney?
Oh, I don't even know that.
Wow.
When she asked for his name, he said, she said, okay, I got it. He didn't say anything
No
Esquire or
PLS,
whatever.
MIID number, no nothing.
Nope. So yeah.
Hold on,
So
Cam. If he's not an
maybe we should look
attorney,
up and find out where he is, because he said
right,
he was in the Columbus area. I don't know if he's in Columbus. And
right,
because I was
because
like, wow, you came all the way here from there, and he's like, well, yeah.
well, no, well, here's the thing. Um, he's in the Columbus, he's in the Columbus area.
That's what he said. I have no
Okay,
reason to believe that he would have lied.
You're rocking with the best. Break it off another hot explosive mix.